He then, 3 days before a scheduled deposition, posted on Instagram he, quote, would love to start a shooting campaign. Mr. Lee's misconduct not only led to that protective order, which required depositions to be held in a secured location with armed officers present. To disbar him, he can apply again in 5 years and try to show that he's been rehabilitated.
Welcome to the Florida Supreme Court. Our first case today is Florida Bar versus Malik Lee, case number 2023-0518.
May it please the court. My name is Mark Mason, and I represent the Florida Bar in this disciplinary proceeding against the respondent Malik Lee. The bar filed a 6-count complaint regarding 24 rule violations involving a 3-year pattern of ongoing misconduct. This occurred in employment discrimination cases filed in federal court in the Southern District, and also occurred in circuit court litigation involving the living conditions of an apartment complex and an attempted class action. Before this disciplinary proceeding, Mr. Lee's misconduct had already been the subject of a protective order, not merely because he disparaged defendants, school officials on social media, calling them liars, calling them corrupt, saying that one would be jailed and that one was a racist. He then, 3 days before a scheduled deposition, posted on Instagram that after this upcoming round of depots, he, quote, would love to start a shooting campaign. Mr. Lee's misconduct not only led to that protective order, which required depositions to be held in a secured location with armed officers present, it also resulted in a 2-year suspension order in federal court, also regarding his recalcitrance in refusing to own up to the objectively threatening content of his post. His conduct also resulted in 4 sanction orders imposing monetary sanctions, which he hadn't paid at the time of the trial and the disciplinary proceeding. It resulted in a gag order, 3 contempt orders, not only for his repeated violations of that gag order, but also for failing to take CLEs to address the ongoing civility and professionalism problems he was exhibiting. And then there was also, yes.
Let me ask a quick question. It seems like the actions that occurred in one instance, in the civil case, they happened in September 2016, 2017. And then the second case, they had that happen between 2018 and 2020. We're in 2024. Why did it take this long to reach the Supreme Court or any place else?
Well, part of it was the scope of the misconduct. Certainly, as he committed more and more violations, it added to the investigation and the time it took to complete that. Some of the later...
I'm sorry to cut you off. So the first referral to the Florida Bar occurred in 2017, right, by the federal court. And you're telling me from 2017 till 2023, it took that long for the Florida Bar to get through at least the initial conduct that generated the referral. Why did it take so long? I'm struggling to figure that out.
Yes, Your Honor, and I understand that this case could have been handled more promptly. And I certainly understand that from the reporter referee as well. What happened is that the bar started investigating these things and decided to file one formal complaint. In retrospect, with how long it took, should the bar have prosecuted on the earlier cases? Probably, yes. But we ended up doing a comprehensive 6-count complaint in 2023 for conduct that spanned from 2017 to 2020.
But once the bar, filed the complaint, the process took, what, approximately 7 months? 6
to 7 months it took from the formal complaint until the conclusion of the 6-day trial.
Okay.
So.
He had been a lawyer, member of the bar, beginning with the first case, the 2016, 2017 case, for only 5 years, correct?
Correct, 2011.
And then when the second case occurred in 2018, he had been a member of the bar for 7 years at that time. So all this behavior, all these issues that were raised in this case happened during his early years. I think he's like 49 years old.
Correct.
So he's admitted in 2011.
Yeah, at the time of trial, the reporter referee says he was 49 years old. As far as the inexperience goes, even if you would consider that a mitigating factor, that's all it is. It doesn't excuse the misconduct. And the nature of the violations we're talking about here were intentional violations of court orders. It was not...
The inexperience might relate to making missteps, going down the wrong path. But when you're told you're going down the wrong path and you keep going and keep going and keep going, that's not just inexperience. That is incorrigible conduct. Am I wrong about that? I mean, that's basically the bar's position, isn't it?
That's exactly the bar's position, yes, Your Honor. You know, and really we sought review for 3 reasons. Obviously, the sanction is the primary one. But within that, there's 2 issues, is the referee's findings of not guilty on count 2, which had to do with the pretrial stipulation filed by opposing counsel. She input an electronic signature on it. There was some confusion as to which version was the correct one, but rather than call her up about it, he does a public filing that accuses her of criminal forgery. And then he follows it up by contacting law enforcement agencies to seek criminal charges against her. The referee found her, Mr. Lay, not guilty on the 2 rule violations at issue in count 2, saying that it was an isolated instance of misconduct.
Yeah, and so that's the way you read the report. I mean, because the report is kind of incoherent on that. I mean, it says that at the top part, but then when it's going through the sanctions, it talks about having found violations on all the charges. So what are we to make of that?
Your Honor, I agree that the largest issue with the report or referee is that it glosses over the underlying misconduct. You could read the report or referee's counts 1 and counts 3 through 6, and you would have almost no idea what the misconduct involved. Count 2 contains the most amount of facts, and it still just talks about the different versions of a pretrial stipulation going back and forth, but it doesn't even mention the fact that he was contacting law enforcement agencies.
So are we supposed to be the ones making the findings then? Because it's hard to read that report as really having made findings. Are we supposed to be doing that now, or what?
Yes, Your Honor. I wouldn't argue for remand in this case because we submitted the court orders that firmly established the misconduct. So with regard to count 2, it certainly wasn't an isolated instance of unprofessionalism. This wasn't just a single nasty email with what he did. This was a campaign to try and get her arrested, to try to paint her as some criminal. And, you know, that violated the 2 rules at issue, which was 4-8.4A and D, having to do with conduct prejudicial to the administration of justice. And it was humiliating and disparaging for the other attorney. And with regards to count 3 through 6, which was mostly focused on the circuit court litigation, the attempted class action, there's almost no findings whatsoever in the report or referee. It just references what the bar's formal complaint charged. And on that issue, what the referee did is she attempted to recommend diversion on those counts. But the problem with that is the rule governing diversions after the submission of evidence says you can only do that when there's minor misconduct. This misconduct was not minor. I mean, even the referee, for, you know, all the omissions that may be within that report or referee, she's recommending a rehabilitative suspension. She recognized this conduct is not minor at all. Diversion is not appropriate, and you can't just separate the counts and isolate your review to say, well, this misconduct was minor even if this other misconduct wasn't.
What is the bar's recommendation? What are you asking us to do?
The bar is seeking disbarment for Mr. Lay in this case. This is his first disciplinary proceeding, and I know generally speaking it's unusual to go straight from no discipline whatsoever to straight disbarment. But the reason the bar is asking for that is because of the 3-year pattern of intentionally violating court orders, especially in the class action litigation. The standard 6.2 deals with serious interference with a legal proceeding and knowing violations of court orders. And those were findings by the presiding judges and magistrates repeatedly in the court orders in which they sanctioned Mr. Lay. They said that he offers these excuses and he attempts to confuse matters and just to rely on his ability to talk his way out of things, but he's not taking responsibility. I mean, we're talking, 2023 complaint versus 2017 misconduct. I understand the delay issue, but at the same time, he's had all that time to complete CLEs, to even enter into payment plans to pay these sanction fees, and he didn't do it until the referee exhoriated him at trial and said, you better do something. And then he comes back to the stand the next day and says, well, I just emailed opposing counsel and I inquired about getting on a payment plan. These were all steps that could have been taken earlier.
And I guess the distinction between suspension and a disbarment, I think, would be harm, right, to the client.
Right.
potential harm. And so I guess the argument is that the clients ended up getting a benefit from the proceeding. It took a while and it was despite this, but can you address the harm aspect specifically in terms of
Right.
disbarment versus suspension?
In count 4, one of the sanction orders imposing monetary fees that was made payable by both Mr. Lay and his clients, first off. And that was because he filed a frivolous motion for default that had absolutely no basis in fact or in law. It led to a completely unnecessary hearing. And these are, by his own words, extremely poor people. They cannot afford to be paying sanction fees for his misconduct, for his inability to understand fundamental legal principles. So there's that. There's also the fact that he's talking about these health concerns that are immediate, that justified immediate action. But this class action case just languished for 2 years, and he never got past filing a complaint that could survive a motion to dismiss. It did no benefit to his clients for him to just struggle to file a complaint without calling someone a slumlord, like he was repeatedly told to do. So one of the cases I relied upon for disbarment is the Florida Bar v. Springer. It also involved a 6-count complaint. It also involved 28 rule violations versus 24 here. It involved a bar complaint that was filed in 2002 regarding conduct that was from 97 to 2000. But there was a pattern there, a lack of diligence, and then a dishonesty in trying to cover up the incompetence when clients were asking for status updates. And what this court said is the only appropriate sanction for this type of conduct is disbarment. And for that reason, I asked for disbarment. I'll save the rest of my time for rebuttal.
May it please the court, Juan Arias on behalf of Mr. Lay. This case has always been about the degree of discipline to be imposed, even at the time of the final hearing. But he went to that hearing acknowledging, apologetic, and more importantly, was able for the first time to tell his story, because this court, this high court, probably is asking, what was he thinking in getting involved in these two litigations? Because that's exactly the first thing I asked when I got involved in this case. His personality traits are based on growing in a military family. He was a military brat, moving around. His father was absent in his military duties in the Air Force, enduring emotional and physical abuse by his mother, living in his home and family, leaving the home and family at a young age of 13, had devastating car accident that derailed his plan to be an athlete in Europe, rehabilitation and loss of reading skills as a result of that accident, circumstances of the murder of his girlfriend based on religion, the death of the mother of his young child, he's a father, and 2 heart attacks, all endured before he was 30. So the question that I've always had and that I pose to the court and I pose to this high court is, what do we do with individuals like Mr. Lay who come with a baggage that will reflect?
So I had a similar question. I guess the flip side of that same question, though, is what is our obligation to protect the public? And so why, if there's this continued pattern that's obviously negatively affecting the clients, should we take that into account more so than the impact to the public?
Justice Sasso, that's a great question, because these 2 cases I was involved in were pro bono. On the second case dealing with Stony Brook, nobody wanted to touch that case. In fact, there's evidence and testimony from a community organizer who is the one that approached Mr. Lay because of the conditions of that location. So these were pro bono. Again, not excusing, but that is a fact in this case. So he jumped in, and his intent was to get the ball rolling, could get this case running, and then he could move out. He was not competent. The water was above his head. We know all of that. But he went in with a good heart and absolutely was the attorneys or the opposing attorneys on both cases ran circles around him. And that did affect emotionally how he responded to this combination of his traits and what was happening, the frustration.
Counsel,
Not an excuse.
I'm sorry to cut you off.
Yes, Justice.
Talk to me about why Springer is not applicable to this case.
Springer is not applicable because of several reasons, Justice Francis. And that has to do with the fact that that case is about, above all, dishonesty. And above all, can be distinguished because it also deals with lack of diligence and communication. So you're affecting clients directly, and you're, in fact, in that case, to tell you how outrageous that case, the facts were, he falsified 24 certificates of title. I mean, this is massive, massive misconduct of this man.
The bar's position is that that case is directly applicable because, I mean, apart from the numerosity of the complaints and the allegations against that particular person, we have a similar circumstance here. And the referee did specifically find, did she not, that he engaged in some level of dishonesty when he had a court reporter, intervene and ask questions to a represented person without opposing counsel there. He was also sanctioned, and his clients also had to, were found also liable for the payment of those sanction orders. So why are those things not the same?
Well, they're not the same because the imperfect representation of Mr. Lay in that second case, the Stony Brook case, was a mixture of not only incompetence but a overzealous effort to help these individuals because of their history and because of the history of the issues that have been already discussed before, the health, etc. So he didn't have a selfish motive on those, unlike on this case where you have an attorney who is practicing on the private side and trying to make money out of these cases. That was not the case here. So he is the one, Mr. Lay is the one that disclosed that document. It was wrong, he took responsibility for that, and that is that. But the level of dishonesty on the Springer case, and diligence is just another level.
If we were in a posture where we were considering your client's admission to the bar ab initio, like he had just taken the bar exam, and this was the record before us, do you think we should admit him to the bar where he's posting things like he's posting online, things I can't repeat on the record here? It would seem to me like he would have a very uphill climb. And so I guess, fine. I mean, let's say we were, moved to suspend your client rather than disbar him. I can't imagine him being readmitted to the Florida bar with a record like this. So help me understand why. Am I seeing that wrong? Is this someone who you think represents the kind of person you would want to represent your family in a dispute? Why should we admit him to the bar?
Just a Curiel, it just happens that I do that kind of cases. And I appear before the board 3-4 times a month. Keeps me busy. And the beauty of the rules of the FBBE is that you get to show rehabilitation. Because this court has plenty of case law that says people can change and can evolve and can learn and can contribute, because by making mistakes, you learn empathy towards others too. So I would gladly and proudly represent somebody that shows to me that he or she gets it, and that she has
where's the evidence? Where's the evidence in the record that he gets it?
He testified, the remorse is there, and the court acknowledged that. He didn't go and fight all of these rule violations. He explained exactly the circumstances behind those cases. We did not go into that investigative hearing to just poke holes at everything.
Yeah, as you know, I'm from Palm Beach County. I'm from West Palm. I'm familiar with Stony Brook since I was a prosecutor and a public defender. Stony Brook's been around. It's been a source of trouble. And very poor people live there, are victimized by other people. And that development obviously needed someone to come in and do what your client did, help, offer their profession to help out. So I can understand that aspect, and obviously anyone would appreciate his effort to try to help out a very needy area. But here, and I've sat as a circuit judge in Palm Beach County for 13 years, and if I was to file a bar grievance for every lawyer who didn't follow my orders, I'd be testifying before the bar every day, because some lawyers just don't. But the question here, it seems to me, it's just, we're talking about the degree of the penalty that he's going to get here. And what his inability to follow court orders just out blatantly, and after being told and warned to follow the orders over and over again, is not your typical case where I order someone to provide better answers to interrogatories within 10 days and the person doesn't do it. And then they're before me and have to decide what to do. It's beyond that. This is like something way out there. But I mean, we also have to consider these clients who walk into his office and they see that license with our picture of our Supreme Court on it, and they have every reason to assume that we say this guy's okay. They have no way of knowing about backgrounds and things like that. I mean, we do have that obligation to the public and to everyone else also to make sure that the lawyer they're hiring is someone who's not going to behave like this. Now, I see from mitigators here that he did not do this for his own benefit. Obviously, he was, and the result of perhaps incompetence. I mean, class action lawsuits are not easy, and it requires a certain degree of specialty to really know how to do them correctly. And he just had this inability to follow court orders for whatever reason. Why should this not, so we're talking about the degree of the penalty, why should he not be disbarred? Why?
Yeah. Justice LaVarga, there is evidence on the record that clients testify as to his professionalism in their case, and there is no evidence whatsoever that in the areas that he practices, which is family law and dependency, no issues. So these two particular litigations really rattled this individual, and I think that because of the nature of his personality, he just did not handle them properly. Then the last one is not to deny the public of the service, encourage reformation or rehabilitation. I think there's plenty of space to rehabilitate him. Let him come back and try to rehabilitate and come back and petition. He has a lot to offer. He's come a long way. His background is just unique. This is a unique case. He may be an outlier, but it's a unique case. And I hope that this court recognizes that there is a lot of talent and passion and great service in the future, if given the opportunity. Thank you.
Thank you very much.
I've heard quite frequently that this is just an instance of two cases. This was an instance of 3 years of misconduct in his first 9 years as a lawyer. This can't be just separated out as, well, it was just 2 instances. 3 years this was ongoing. And, he was overzealous because he had a lot of passion and empathy. This court addressed that very recently in Florida Bar v. Schwartz and said overzealousness is not some personality trait that you get to use as a chit to cash in when you're facing discipline. He had a duty to be competent, to be professional. He didn't do that. He didn't attempt to do it in the class action litigation. Anything that he accomplished outside of the litigation had nothing to do with his behavior in court. I heard a distinction that, well, the Springer case is distinguishable because it involved dishonesty. Justice Francis pointed out that he did do dishonest conduct with regard to the taking of that deposition. I would invite this court to review Exhibit 94, the bar's exhibits. It shows the text messages that went between Mr. Lay and the court reporter that showed he knew very well he could not meet with this witness, this represented party. And so he was sending her in there with a list of questions, with documents illegally obtained. And then I heard them say, well, he publicly filed it. He disclosed it. And so that took care of that. Well, he publicly filed though. And the disqualification order addressing that conduct says he did that with the intent to try and disqualify his opposing counsel.
So do you, the counsel on the other side sort of characterize this as, to the extent that there's the sort of macro protection of the public in terms of sort of general deterrence, but in terms of this particular lawyer, is disbarment more of a punishment, or do you believe that it's more prospective protection of the public if that were to be the outcome here?
I think it's necessary to protect the public.
From him, or just from this sort of behavior in a sort of general deterrence kind of way?
To ensure his rehabilitation, certainly, because he didn't take any steps he needed to take to show rehabilitation in time of trial. For the public, because, you know, we shouldn't be facing in the future another instance where he undertakes representation, gets passionate and apathetic again, and then when things go sideways, suddenly he's just blowing up at people and using his childhood to say, well, I'm just a passionate person, that's how I was raised. You know, it needs to protect the court system because, for instance, these are just the court orders that address this misconduct. It'd be twice as big, but I printed it on both sides of the paper. It's a huge waste of court resources to deal with this type of misconduct. So, you know, for all those reasons, I would ask this court to disbar him. And I'm not saying permanent disbarment. I'm not saying he's beyond the pale and he can't come back and reapply for 5 years. Disbar him, he can apply again in 5 years and try to show that he's been rehabilitated. Thank you, Your Honor.
Thank you.